Hi. As you well aware that I am Dr. Jetting Elosa, running a YouTube channel called Law Speeches. You know, day before yesterday, India has seen a ghastly incident in which 242 innocent passengers have been lost their lives. That is Air India flight 171, which was bound to London from Ahmedabad, where on account the huge accident was occurred, and 12 crew members also lost their lives. Entire nation or the world has been shaken by this incident. And in addition to this accident has resulted into death or injuries of the innocent medical students who were staying who were taking lunch at that point of time. So today we discuss what are the legal implications and what are the rights the families have from the Air India, from the Boeing company, from the government. You know, if you go to international law, we have the air law or air aviation law is there, where on account the countries have been traversing the aircrafts in the skies. There are five freedoms of the air is guaranteed under the international law. For that reason, we have number of conventions are there. One is Warsaw Convention. Other is a Chicago Convention. Then we have the Montreal Convention, Hague Convention. So different conventions are there which are bounding us for air travel in the air. The state parties have been signed those conventions, and they are bound to follow these rules which are enshrined in those conventions. Then here we are discussing the rights of families who have been lost. Who is liable, who is accountable to pay the compensation? Whether the Boeing company, whether the Air India, the carrier, whether the government of India, or whether the companies which have taken maintenance of the different systems of the aircraft. So who is liable? For that reason, if we analyze the Montreal Convention of 1999, for which the India signed the convention, and the Article 17 clearly stipulates that the carrier liable for any sort of death or injury of a passenger on the boat. So this is restricted to only to the passengers. Article 17 does not provide any kind of relief to the ordinary persons who lost their lives in the hostels on the ground. For that, we have the strict liability principles are there, absolute liability principles are there. So, again, the Montreal Convention under Article 21 provides that the principles of strict liability, under which every passenger is liable to get, means the dependents are right to get 128,821 SDRs are equivalent to 1,70,000 US dollars as towards the compensation for losing their life. And for that, the passengers who are traveling or the dependents who are traveling in the aircraft, no need to prove the death was happened. It is automatically under the principle of strict liability, the compensation will be paid to the dependents. If the dependents of deceased passengers, they prove that there is a negligence on the part of the carrier or company or any third party involved in the operation, in such scenario they can get more than that compensation. Then we have one more convention called the Chicago Convention of 1944, where on account the International Civil Aviation Organization was founded or established in Chicago, the United States of America, which purely deals with the safety standards of the aircraft and the companies which are running such aircrafts. Annex 13 is there in that convention, which provides aircraft incidents has to be properly investigated and the report should be submitted to ICAO by each airliner if any sort of accident occurs. Then the liability of the companies. You know, the accident to here in India was, the company is, aircraft was Air India is operating the Boeing 171. So primarily the Boeing company, to say the Air India is liable for the payment of the compensation as per the Montreal Convention is concerned. If there is a loss of luggage or loss of anything, property of the passenger, or delay or disruption of the flights with unreasonable cause, then the Air India, the carrier, is liable to pay the compensation. Then we have to know what is the manufacturer liability. So manufacturer of the aircraft like the Boeing company or Airbus companies, they also liable if the aircraft had developed technical snags or defects and there is a any sort of defect is there, then in such scenario the company which is manufactured the aircraft is liable. Then this is also be called as a product liability loss, product liability under the civil aviation laws are concerned. Then we have to know where we have to institute the lawsuits or cases. Where for that the international law, aviation law clearly provides that where the aircraft is manufactured in that home country, a suit can be filed. Suppose Boeing is manufactured in the United States, because it is manufactured there, then the passenger dependents can file cases in the United States, or the country where the accident has happened, there also we can file the cases, lawsuits. Then in addition to that, if the crash is due to the improper maintenance, third parties have not at all bothered to maintain it. In such scenario, that place also where the third party are there, then the case can be filed. Then in addition to that, we can file cases under against the airport authorities. You know, in India we have the DGCA, Director General of Civil Aviation Organization, is a regulating and licensing authority for all the airports, and which also controls the air traffic in India. Then the DGCA also been liable for this sort of payment of compensation to the innocent victims. Then the question comes to us again, that where a proper place to file suing the such companies or organizations. For that, the international civil aviation law clearly provides that the victims' families, they can file cases in India, because the incident has happened within the territory of India, that is in specifically in the Ahmedabad. Then where the passengers are permanent residents, there the case can be filed, or where the airline home country is there also a case can be filed. Then otherwise they can file the case, a lawsuit in the where they got purchased the ticket, because at that place the amount has been gone to the company. So where they got purchased, that means suppose if Indian citizen got purchased a ticket in Sri Lanka, in Colombo, then that Indian citizen has the right of filing here in Colombo, in Sri Lanka, where the manufacturer is there. If the technical liability is there, he can file the case there also. Then we have what kind of damages we can be claimed. So we can claim the damages for death or injury, and also we can claim the moral damages and punitive damages. If something is happened, that special damages can also be filed against the such aircraft carrier or manufacturer or technical persons are third persons are even against to the government. Then the tragic incident is being got investigated by the Director General of Civil Aviation Organization, and it is competent enough to investigate the matter as per the conventions are concerned, and it is investigating. And we got a news that the black boxes, which are very important for the unearthing the mystery of the crash, has been found, and the such after getting of such report, the report should be submitted to the ICAO, International Civil Aviation Organization, which is located in Chicago. Then the and the ICAO can also send the special team to India to unravel the truth for this sort of tragedy. So, if we refer to the previous cases, then we have the Air India again, flight 1344 Kochekoat in 2020, because of the liability of the airport authority and also the infrastructure and improper maintenance, the Air India and the government were fined to pay the compensation to the victims of that accident. Then we have the in Malaysian airline MH370 case, which has happened recent past, where the complete aircraft was missed. It is not recovered. As on today also it is not recovered. In that case also the claims were pursued, and the passengers, their families, the dependents were given sufficient compensation by the airliners and carriers and also concerned parties. Then question comes here to our minds. In India, the recent past, we have seen that day before yesterday, the aircraft has fallen upon the government medical college, hostel, and the innocent students who are taking meals, they lost their lives. And there are around 50 to 60 students who are got injured. Who are liable for it? Because the convention, the Montreal Convention, only speaks about the paying of compensation to the passengers or their families. It does not talk about the innocent persons who are there on the ground. So for that, we have the principles of strict liability or absolute liability, which is very famous by R versus Fetcher case of 18th century. If you are keeping the dangerous things with you, then you are the liable, whether it may cause any sort of damage to the unconcerned persons. That has happened in R versus Fetcher case, when there was a lot of water was stored and it was leaked and the innocent lives were lost. So absolute liability principles are there, that is strict liability principles are there. As per that, the innocent students, their families, their dependents can claim the compensation from the carrier of the aircraft, that means Air India, or to the manufacturer of the aircraft, that is a Boeing company, or even from the DGCA or Government of India. Though the government has given some sort of ex gratia, but legally they can claim that they lost the legal heads of the medical students whose lives have been lost. They can claim that they got irreparable loss because of the loss of their children. For that, they have to prove the age is a factor, then occupation is a factor, then dependents, how many dependents are there to that deceased person, also a factor, and they can file any sort of cases in the civil courts, and also under the right to life principles, which is there under the Article 21 of the Constitution of India. They can go to the high courts or the Supreme Court and the relevant provisions like the Article 226 and Article 32 respectively. So, it is very, very sad. Then we can discuss the some important case laws which is our Supreme Court has pronounced with regard to the strict liability principles, or to say in aircraft death cases and giving up the providing of the compensation. Union of India versus the Prabhakaran Vijay Kumar in 2008, volume 9, SCC, page number 517. In this case, the Supreme Court has stated that railways are liable to pay compensation to the if their acts to the innocent persons. In this case, what happened? The railway electric wire has been fallen upon a passerby. So, the principles of strict liability was applied, and the compensation was claimed by the parties, and the compensation was awarded, ratified by the Supreme Court. Though it is not a aviation case, but this case also applicable to aviation matters are concerned. Then we have MC Mehta versus Union of India case. Case is 1997, volume 1, SCC, page number 395. It is also be popularly called as the oleum gas leak case. In Delhi, the gas was leaked from the oleum company. It is a private company. In that scenario also, the Supreme Court has stated that the strict liability principles are there, and the company is liable to pay the adequate compensation to the concerned persons who got injured or who got succumbed to death in that case. Then we have the one aircraft case, that is the Indian Airlines versus Madhuri Chowdhury 2002 case, All India Reporter, volume 3, 2991, page number. So in this case also, the Supreme Court has clearly stated that the claim, the principles of the strict liability can be applicable, and the company is duty bound to pay the compensation to the innocent passengers as well as the persons who are there on the ground. If their property is damaged, if they got injured or death is occurred in such situation, under the principles of the strict liability, they are liable to get the adequate compensation from the airline concerned companies. And one more case, that is the M.K. Shah engineering case, also the Supreme Court again applied the principles of the strict liability and given adequate compensation to the victim family. So this is the various complexities of the various factors which involve in the air aviation law is concerned, And throughout the world, the domestic or international level, thousands of aircrafts are flying and across the globe. And if anything happens, the international aviation law is there, domestic law is there, then the tortious law is there. All these clubbed together, they can be given compensations. So this is a very complex issue, but we have provisions have been made for providing the adequate compensation to the victims. So lastly, I pay my tribute to all the families who lost their lives in the aircraft tragedy of the London-bound, Gatwick-bound aircraft day before yesterday, and also the students who got died or injured during this tragic, ghastly incident. So thank you for patiently hearing my lecture. I would like to request all of you to subscribe to my channel if you feel that my lecture is a good or knowledgeable. Circulate among your friends and communities. Thank you one and all.